Hello, hello. हेलो हेलो आ रही है बात सर? आ रही है सर? मैंने आपको बताया आप
सुशेन आ रही है आवाज? सुशेन ऊपर जाके बात कर जरा। बात कर, मेरी आवाज नहीं है?
Hello, mic testing. Hello. Hello.
हेलो माइक टेस्टिंग, हेलो हेलो। कितना चल रहा है? कौन सा चाहता हूँ? चल गया।
मीटिंग में है, किस मीटिंग में है या जूम उसमें यूट्यूब पे थोड़ी। हेलो हेलो, ऑडिबल है बिल्कुल ठीक है, साफ क्लियर।
Please. Very good morning to everyone. एक मुझे फैन स्लो कर दो यार। एक स्टेप। Mine is not a lecture. I am not going to teach you anything which you don't know. I'm just going to highlight and underline some of the concerns expressed by the Supreme Court, the highest court of this country, in few of the last judgments, which have been made part of the curriculum of the judicial academies, and we are under directions to hold programs for the benefit of our judicial officers. So it is only in that context that I am here before you. I have just few things to share, and learn from your experiences. So please feel free to interact and share your experiences, particularly the senior judicial officers who are here, because they are more experienced and they are dealing these problems day in and day out, and have a first-hand experience of all these issues which concern us all. First of all, just to have a quick relook what we did yesterday. You see, cases are delayed endlessly, and judicial officers are not the only to be blamed for that. There are many factors contributory to these delays. But judicial officers have the key role. You have the authority to control these delays wherever possible. And that has to be used at times for the common good. There are certain cases where it is found that there is evidence is of such a character that it is not possible for the defense to break or win over the witnesses. Then the last resort in such cases is to delay those cases. And it is true for economic offenses also. Where they find it difficult to break the process of law, then delay is used as an effective weapon, and that has to be checked. Rather, it is our responsibility as judicial officers to see that all sensitive cases don't get derailed because of these tactics. Because in such cases, the system as a whole is being closely watched and is at test. So therefore, you have to devise and innovate the ways and means to ensure that those cases are dealt effectively, and these dilatory practices are checked. I have seen that many changes have been made in law, particularly in procedural law, earlier also to expedite the trial. But most of the times, I have observed, those have not been applied effectively in spirit. As a result, there was no change, visible change on ground. The provision for filing evidence affidavits was introduced way back in 1983 in the CRPC as section 510A. But I'm not sure how many of you have seen throughout your service career that affidavits are being filed of those witnesses whose testimonies are only formally incorrect. I have not seen any prosecutor coming forward with an affidavit saying that, sir, he is a formal witness only. There's no need to call him. I have not at least seen in my career, though I have made many prosecutors to file affidavits wherever it was possible. But it was for the prosecution to take a cue and come forward. We as three agencies, investigating agencies, prosecutors, and judicial officers, have a common goal. Investigators' role is to search for the truth and place it before the court for judicial scrutiny. Prosecutor's role is to assist the court, produce the evidence, whatever material is collected by the investigating agency, see to it which is relevant, which can be dispensed with, and which is very essential, which can't be dispensed with. Also see to it that trial is held expeditiously and take all steps to ensure that the trial is expedited. But that's not happening. And judicial officers, they have own reasons. Somewhere we have to think that we have worked in unison. All have to pool our energies towards common goal, common end, which is the ultimate purpose of holding these proceedings. But many times that's not happening. So these are the areas which are cause of concern and which are ultimately responsible for large scale of acquittals. Acquittal is not just an acquittal. In any case, we have to keep in mind that there are conflicting interests. On the one hand, there is accused who is facing the charge of having done something which is not at all acceptable to the society as a whole. There is a victim who is wronged, who is immediately affected by the unlawful act, which is classified as offense by the accused, who is facing the charge. And the society as a whole, because any society needs peace, for progress. It's not possible that society struggling with conflicts to progress. So you have to balance these conflicting interests. The whole purpose of holding the trial is to reach at the truth. There may be a counsel who is defending the accused. There may be a prosecutor who is interested in the conviction. But they are supposed to assist the court in arriving at a just conclusion, and they are supposed to assist the court. Their role is primarily to assist the court. So you have to, at times, remind these people of their role, the importance of their role, so that we march in the right direction. Now, you see a new act, BNSS, certain timelines have been given to conclude the trial. In the given scenario, I don't know what is going to happen, but it would be a Herculean task to meet these deadlines. But believe me, now these deadlines are there. We are going to be questioned. It's not that we will question all the times. No, we are going to be questioned for whatever we are doing, even to the best of our abilities, even round the clock, 24/7. Still, we can't escape. Because it's difficult, given the quantum of the pendency, to meet these deadlines. And in addition to that, certain new offenses have been added, which would further add to the burden of the courts. And there is no change in so far as the infrastructure is concerned. The facilities are concerned. Some of you yesterday pointed out that you had the difficulty with some police officers. Why you are dependent on police officers? That should be addressed first. Every judicial officer, why can't he be provided a domestic help so that he devotes his full time for the judicial work? He makes better use of his time. But if you have to press your clothes, wash your clothes, cook for yourself, would it be possible for you to meet the targets? These are the challenges which nobody talks and nobody tries to understand. So far as PSOs are concerned, they are meant for different purposes. But in one way or the other, we sometimes take favor from these people. They provide us PSO and SPOs, just as domestic helps. For these reasons, but we can't claim as a matter of right, we can't ask them to provide all these facilities because they are not so. It is out of courtesy only that they provide these facilities. So far as even PSOs are concerned, there is a rigorous exercise. That perception is seen. Thereafter, seeing that the officer really is under threat from some unwanted elements, that PSO is provided. Though for other reasons, they may be provided to many other people who don't deserve. But for judicial officers, since we always talk of law and procedures, and we are replied back in the same kind. So these are the factors which you have to manage yourself till some better arrangement is made. Now, so far as the provisions of bail are concerned, we had a lecture yesterday, and most of you are already aware of the provisions. Basic provisions have remained the same right from the ancient times. But it is only in the application that we have either added something or subtracted something, which have resulted in many unwanted uncertainties in the application of law, as a result of which now, as of now, you see throughout the country, more than 2/3 population, jail population is of under trials, which is an alarming number. And those, even those, are there for years together waiting for trial. if you look at the problem in J&K's perspective, the problem is even worse. Here, more than 83% under trials are there. So see the amount of problem. So it has to be addressed somewhere. We have to do something to ensure that these unfortunate individuals who have walked on the wrong side of the law don't suffer perpetually. As is the topic of today, we have to discuss two directions passed into judgments by the Honorable Supreme Court. And I'll be quoting from those judgments only. And I'm sure you must have read on your own also. Anika gloss रखोगे? I'm sure you must have gone through the judgments earlier also, because these were the judgments wherein directions were given to all the high courts to circulate these judgments to all the judicial officers. And in compliance to those directions, these have been circulated to all the courts, and thereafter, there was a further direction to the high courts to file compliance. And compliance reports have also been filed thereafter. So I would just be highlighting some of the points for your convenience and for my convenience also, which is important to keep in mind. It was way back in 1924 that High Court of Calcutta in Nagendra versus King Emperor held that the object of bail is to secure the attendance of the accused at trial, that the proper test to be applied in the solution of the question is whether bail should be granted or refused is whether it is probable that party will appear to take his trial and that it is indisputable that bail is not to be withheld as a punishment. Then two other cases are cited. Significantly, these are merit conspiracy cases. And it was held that principle which was established was that the discussion should be, that this discretion should be, it is in non-bailable offenses, the discretion is with the court or the officer who makes the arrest. But this discretion is not absolute or unguarded. It has to be exercised on some settled principles. And it is said that it has to be exercised judiciously, keeping in mind those parameters. It was further held that it was very unwise to make an attempt to lay down any particular rule which will bind the courts having regard to the facts and facts that the legislature itself left the discretion of the court unfettered. It is rather dangerous to make an attempt to classify the cases and to say that in a particular class of classes, bail may be granted but not in other cases. So it is difficult to lay a straitjacket formula which would apply uniformly to all the cases where the bail should be granted or where the bail should not be granted. It was left to the judicial wisdom of the courts to see in a particular case, because the courts have to see no two cases are alike. Offense may be same, but the circumstances of the two accused may be entirely different. The backgrounds and the reasons, immediate cause which led to the commission of the offense may be entirely different. So it has to be seen in the facts and circumstances of each particular case as to whether discretion is to be exercised in favor of grant of the bail, or it is a case of exceptional nature where the discretion is to be exercised otherwise. With the passage of time, the courts have defined the factors which are to be kept in mind while considering a bail application. And it was way back in 1962 in State versus Jagjit Singh, AR 1962, Supreme Court 253, wherein it was held that various considerations such as nature and seriousness of the offense, the character of the evidence, the circumstances which are peculiar to the accused, a reasonable possibility of the presence of the accused not being secured at the trial, reasonable apprehension of witnesses being tempered with the larger interest of the public at large or the state, and similar other considerations which arise when a court is asked for bail in non-bailable offenses. These factors in subsequent decisions came to be further elaborated upon. Kalyan Chandra Sarkar versus State of versus Rajesh Ranjan alias Papu Yadav brothers is another case. And it came to be finally concluded that nature of the accusations, the severity of the punishment, the position of the accused vis-a-vis the victim, and possibility of influencing the witnesses or tampering with the evidence, possibility of fleeing from justice, and interest of the society as a whole are the factors, some of the factors which are invariably to be considered by the court while considering a plea for bail. Finally, finding the situation very serious, some of these conditions have been relaxed. And even the provisions of Section 41 and 41A came to be incorporated with that object only. Arrest is not to be made just as a matter of course. There has to be reasons for that. Now you will see in every crime, immediately there is a hue and cry that arrest is not made, arrest is not made. A lot of focus is to see only that accused is arrested immediately. But by forgetting that arrest of an individual leaves a scar on that individual forever. He may be acquitted later on, or he may be convicted, but immediate arrest always have drastic consequences. So it is not to be made as a matter of course only. Certain parameters have been defined before going for arrest. And now it is fortunately for the police officers to see before making arrest that these conditions are met, and he has to record reasons. And those reasons are to be scrutinized by the magistrate while granting remand. I could go through the figures mentioned in the judgment itself, that in 498A cases, this provision was basically meant for the protection of the woman. But over that period, it has been used more as a tool of harassment by disgruntled elements. And in most of the cases, it has been abused because police officers, they never realize what drastic consequences it would have afterwards on the matrimonial life. All those cases where arrest is made ultimately end up in breaking of the family. I remember one case. The man was accused of harassing his wife, and police raided his residence at 2 a.m. midnight. The man was arrested. After 1 or 2 days, when he was released, the presiding officer tried to pacify him and told to arrive at some settlement with the wife and take her back. But the reply of the man was that, come what may, you may arrest me again, send me to jail again. Whatever may be the consequences, I may have to remain in jail for life, but I will not take this lady back. Ultimately, the situation went out of control, and the family was broken. So these aspects are never considered by the police. They are not sensitive. Their motto is to arrest first arrest, follow the rest. Thereafter, they proceed what is to be done. And that's the power to arrest is the one factor which accounts for large scale corruption in police. That's the source of corruption. It is this power which is abused and which is a reason for rampant corruption. To control these powers, these provisions have been amended. And now you are already dealing with these applications in all offenses, all cases where the punishment is up to 7 years. Certain points have to be kept in mind before going for arrest. He has to justify why to arrest. And thereafter, it is for the magistrate to scrutinize and formulate his own independent opinion whether the arresting officer is justified in making the arrest. And any deviation in this regard invites administrative action. So, must be following all these guidelines earlier at your places. Yeah, 41A is also here. Yes. Yes. So it has to be ensured that arrest is not to be made as a course, but it has to be a case of necessity only when there are reasons to justify. It is not merely that there are apprehensions, vague apprehensions. He has to collect some material, place it before the magistrate for scrutiny, that these are the reasons wherefrom he has derived this satisfaction that if this accused is left free, he would either tamper with the evidence, influence the witnesses, or flee from justice. The gravity of the offense, severity of the punishment, these have been left out. These are to be seen in economic offenses. Economic offenses are the offenses which affect the society as a whole. In general offenses, there may be 1 or 2 victims. There may be some individuals. But in economic offenses, the society as a whole is made to suffer and in a way is the victim. So in those cases, these are the factors which have to be taken care of. Otherwise, it is not the requirement, or it is not mandatory that bail should be simply denied because of the severity of the punishment, which was not the case earlier. If you go back to 1924 judgment, which I quoted from this judgment only, Endra Kumar Pantil's judgment. It is the considerations were at that point of also the same, because denial of bail or keeping an under trial in jail during the trial has a substantive amount of punishment. Punishment before trial is something which is frowned with in every civilized society, which is something which is not acceptable. So, I will quickly go through these important points. The first judgment is of Arnesh Kumar versus State of Bihar. It was a case of cruelty, where the man was denied anticipatory bail, firstly by the Sessions Court and thereafter by the High Court, and the matter ultimately landed up in the Supreme Court. And the punishment for 498 is, I think, 3 years. So imagine the plight of a person who had to travel to the highest court of the country just to seek bail. Here, some of the figures which I mentioned earlier have been mentioned. The National Crime Records Bureau, Ministry of Home Affairs, shows arrest of 1,97,762 persons all over India during the year 2012 for the offence under Section 490A. 9.4% more than in the year 2011. Nearly a quarter of those arrested under this provision in 2012 were women. 47,951 were women who were arrested in a particular year only, which depicts that mothers and sisters of the husband were liberally included in their arrest net. Its share is 6% of the total persons arrested under the crimes committed under Indian Penal Code. It accounts for 4.5% of the total crimes committed under different sections of the Penal Code, more than any other crime except theft and hurt. The rate of charge sheet in cases under Section 498A IPC is as high as 93.6, while the conviction rate is only 15%, which is lowest across all heads. As many as 3,72,706 cases were pending trial, of which on current estimate nearly 3,17,000 are likely to result in acquittal. So then the Honorable Supreme Court highlighted the concerns. Arrest brings humiliation, curtails freedom, and scars forever. Lawmakers know it, and so also the police. There is a battle between the lawmakers and the police, and it seems that police has not learned its lesson. The lesson implicit and embodied in the CRPC. It has not come out of its colonial image despite 6 decades of independence. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of the public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by the courts, but has not yielded any result. Power to arrest greatly contributes to its arrogance, so also to the failure of the magistracy to check it. Not only this, the power of arrest is one of the lucrative source of police corruption. The attitude to arrest first and then proceed with the arrest is despicable. It has become a handy tool to the police officers who lack sensitivity or act with oblique motives. These are the observations of the Honorable Supreme Court. How serious the situation and how sensitive we are who have been the guardians of the rights of the citizens is something which we need to ponder over. Then role of the magistracy is also discussed. Our experience tells us, and it is para 9, I'm reading from, our experience tells us that it is not exercised with the seriousness it deserves. In many of the cases, detention is authorized in a routine, casual and cavalier manner. Before a magistrate authorizes detention under Section 167 CRPC, he has to be first satisfied that the arrest made is legal and in accordance with the law and all the constitutional rights of the person arrested. Is satisfied. If the arrest affected by the police officer does not satisfy the requirements of Section 41 of the Code, magistrate is duty bound. The magistrate is duty bound not to authorize his further detention and release the accused. In other words, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish to the magistrate the facts, the reasons, and its conclusions for his arrest, and the magistrate in turn is to be satisfied that the conditions precedent for arrest under Section 41 CRPC have been satisfied, and it is only thereafter that he will authorize the detention of the accused. The magistrate, before authorizing detention, will record its own satisfaction, maybe in brief, but in the satisfaction must reflect from but the satisfaction must be reflected from. It shall never be based upon the ipsi dixit of the police officer. For example, in the case of police officer considers the arrest necessary to prevent such person from committing any further offense or for proper investigation of the case or for preventing an accused from tampering with evidence or making inducement, etc. The police officer shall furnish to the magistrate the facts and the reasons and the material on the basis of which the police officer has reached its conclusion. So it is not simply by saying that this is going to happen if he is released. He has to justify justify with the material. In all those cases where the police officer doesn't find it necessary to arrest an accused, he has to communicate his reasons within 2 weeks to the magistrate as well as to his superior officer. But as I told you earlier, police officers are more interested in making arrest rather than not making. So it is very rare, but in such cases, he has to issue a notice to the accused. And if he responds, extends his cooperation, then he is not to be arrested. Just a moment. I'll take early 10 minutes more. Thereafter, we'll discuss, and I am here to know from you only. We'll be discussing your experiences because you are the actual officers who are dealing on ground, applying these provisions day in and day out. Your experiences matter. And whatever problems you are facing, I have to know from you. But just a moment, let me first go through these judgments quickly. Then para 13, certain guidelines been laid down. All the state governments to instruct its police, the first guideline is all the state governments to instruct to the police officers not to automatically arrest when a case under section 498A of IPC is registered, but to satisfy themselves about the necessity for arrest under the parameters laid down flowing from section 41 CRPC. Number 2, all police officers be provided with checklist containing specified subclasses under section 41, subsection 1, B, out second. The police officers shall forward the checklist duly filled and furnish the reasons and material which necessitated the arrest while producing the accused before the magistrate for further detention. The magistrate, while authorizing detention of the accused, shall peruse the report furnished by the police officer in terms aforesaid, and only after recording its satisfaction, the magistrate will authorize the detention. The decision not to arrest on an accused be forwarded to the magistrate within 2 weeks from the date of institution of the case, with a copy to the magistrate, which may be extended by the superintendent of police of the district for the reasons to be recorded in writing. Notice of appearance in terms of section 41A TRPC be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the police superintendent of police of the district for the reasons to be recorded in writing. And number 7 is failure to comply with these directions shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of the court to be instituted before the High Court having territorial jurisdiction. Authorizing detention without recording reasons is for the magistrates. as aforesaid by the judicial magistrates concerned shall be liable for departmental action by the appropriate High Court. So, is the kind of concern flagged by the Honorable Supreme Court and leading to the issuance of these directions, which otherwise are part of the law. Most of these directions are the replication of the provision itself, except those calling for administrative action. Another judgment is Siddharth versus State of Uttar Pradesh. This judgment is in reference to the provisions of first one CRPC, section 170. And the language of the section was that accused is to be produced in custody. The term custody was dealt elaborately by the High Court way back in 2004. And I'll just read a few lines from the judgment. In court on its own motion versus Central Bureau of Investigation, 2004, 72, DRJ 629, the Delhi High Court dealt with an argument similar to the contention of the respondent that Section 170 CPC prevents the trial court from taking a charge sheet or record unless the accused is taken into custody. The relevant extracts are as under. The word custody appearing in this section does not contemplate either police or judicial custody. It merely connotes the presentation of accused by the investigating officer before the court at the time of filing of the charge sheet, whereafter the role of the court starts. Had it not been so, the investigating officer would not have been vested with the powers to release a person on bail in a bailable offense after finding that there was sufficient evidence to put the accused on trial, and it would have been obligatory upon him to produce such accused in custody before the magistrate for being released on bail by the court. It is not always necessary that an arrest is to be made. It is rather the discretion of the investigating officer, even in non-bailable offences. Even before the judgment in Arnesh Kumar's case, that was the position. The police officer was having the powers to release on bail even in those cases where defense involved was non-bailable. So, but a practice in some courts was noticed that at the time of the presentation of the charge sheet, when the accused was produced, who was not arrested during investigation and who otherwise cooperated with the investigation, but the court chose to remand him to judicial custody. This led to reprimanding a very senior judge from UP by the Honorable Supreme Court, who at that point of time was about to be or under consideration for elevation. A person was arrested simply because the court was insensitive to the drastic consequences which followed if someone is arrested. And it was in this context only that this judgment was circulated for the convenience of all the courts and made part of the directions were to make it part of the curriculum of the judicial academies also. The Supreme Court noted in numbering of the paras is not there. We are in agreement with the aforesaid view of the High Court and would like to give up imprimatur to the said judicial view. It has rightly been observed on consideration of Section 170 of CRPC that it does not impose an obligation on officer in charge to arrest each and every accused at the time of filing of the charge sheet. We have in fact come across cases where the accused has cooperated with the investigation throughout, and yet on the charge sheet being filed or non-bailable non-bailable warrants have been issued or his production premised on the requirement that there is an obligation to arrest the accused and produced him before the court. We are of the view that if the investigating officer does not believe that the accused will abscond or disobey summons, he or she is not required to be produced in custody. The word custody appearing in Section 170 of CRPC does not contemplate either police or judicial custody, but it merely connotes the presentation of the accused by the investigating officer before the court while filing the charge sheet. Once the investigation was complete, the charge sheet was presented. Just taking him into custody, just to make him to taste the process of law, was something which was deprecated by the Supreme Court in this case. And the next judgment is Tendra Kumar Antil versus CBI, 2022 AIR Supreme Court 3386. This judgment has taken care of all previous judgments governing the subject, even the judgments which I referred earlier, those are also reproduced here in this judgment. It is a continuing matter, and is still under consideration before the Honorable Supreme. And compliance reports are being taught regularly. In the concluding paras, following directions have been passed. The Government of India may consider the introduction of a separate enactment in the nature of a bail act so as to streamline the grant of bail. This is something which would drastically control the jurisdiction, which otherwise was vested with the courts. But some reasons the courts have not been able to control. Now the law would regulate the exercise of this discretion, and thereby little choice would be left with you. And this is a suggestion coming from the highest court to the government. Had it been done otherwise, the situation would have been understandable. But it is the highest court which is making this suggestion. That itself reflects the seriousness of the issue. The investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and the directions issued by this court in Arnesh Kumar. Any dereliction on their part has to be brought the notice of the higher authorities by the court, followed by appropriate action. The courts will have to satisfy themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused or grant of bail. All the state governments and the union territories are directed to facilitate standing orders for the procedure to be followed under section 41 and 41A of the code, while taking note of the order of the High Court of Delhi dated 7th of Feb 2018 in writ petition so-and-so, and the standing order issued by the Delhi police, standing order number so-and-so, to comply with the mandate of section 141A of the code. The next is, there need not be any insistence of a bail application while considering the application under section 88, 170, 204, 209 of the code. There need to be a strict compliance of the mandate laid down in judgment of this court in Siddharth's case. The state and central governments will have to comply with the directions issued by the court from time to time with respect to constitution of special courts. The High Court, in consultation with the state governments, will have to undertake an exercise on the need for the special courts The vacancies in the position of presiding officers of the special courts will have to be filled up expeditiously. High courts are directed to undertake the exercise of finding out the under trial prisoners who are not able to comply with the bail conditions. After doing so, the appropriate action will have to be taken in light of Section 440 of the Code, facilitating the delays. While insisting upon the shortage, the mandate of Section 440 of the Code has to be kept in mind. An exercise will have to be done in a similar manner to comply with the mandate of Section 436A of the Code, which now corresponds with Section 479 of the BNSS, both at district level, district judiciary level, and the High Court level at the earliest, and earlier directions by this court in Bhim Singh's case, followed by appropriate orders. Bail applications are to be disposed of within a period of 2 weeks. And that's the timeline for disposal of the bail applications. If the provisions mandate otherwise, except if the provisions mandate otherwise, with the exception being an intervening application, applications for anticipatory bail are expected to be disposed of within a period of 6 weeks, with the exception of any intervening application. All state governments, union territories, and high courts are directed to file affidavits and status reports within a period of 4 weeks. So, these are the directions which have been asked by the Honorable Tax Court, and the very intervention of the Honorable Supreme Court in these matters, which otherwise would end up at the most with the High Court, is really a matter of concern. You must have seen that in recent judgments many a time, Supreme Court has not been very kind while issuing bail orders, and even high courts have been reprimanded for not considering the applications in the right perspective, leading to a large number of bail applications being filed before the Supreme Court. So, the purpose of this workshop was to highlight some of these concerns and to share with you the positive directions to all the courts issued by the highest court, so that no individual is deprived of his life and liberty, save as necessitated in the facts and circumstances and duly authorized by the process of law, as is the hallmark of the Article 21 of the Constitution. If you see the problem from Indian point of view, we are a heterogeneous society. having more than 40% of the population being illiterate, and even literacy rate, so far as the government figures are concerned, who is to be treated as literate is again a question which can be debated upon. So these people, mostly from underprivileged classes, have no means of sustenance. And if these continue to languish in jail, you can well imagine the quantum of adverse impact on their families if they happen to be the breadwinners for the family. It is important for all of us to keep in mind the abode, spirit of law, and to apply it with that force only, so that at least we don't become a party and are not accused of any conduct contrary, which is not acceptable or which is considered not in accordance with law. In a democratic society, everybody has a right to question even the highest authority, because here law is supreme and all are subservient. We are all servants of law. With the progress of society and coming of legislations like the Right to Information Act, now most of the information is in public domain, and anybody can view what is happening in a particular case. So try to make it to the best of your understanding, your time constraints, that proceedings are expedited, targets are met, and no one suffers for want of inaction or inadequate action. So thank you very much for very patient hearing. We'll take a short break, and after taking tea, we'll be assembling it and be discussing further. Please. Thank you. आइए please.
done in file, paperwork.
जी जी
This trend has now emerged among the police officers.
तो आपने अच्छा है अपने तौर पे उसको टैकल कर लिया। ये भी तो देखना है कि वो सर्व भी हुआ है कि नहीं हुआ है। सेरेमोनियल या पेपर वर्क के लिए तो कंप्लायंस तो नहीं की है।
Provision says
Yes.
that it could be served.
यस यस
And insofar as service is concerned, I think all those parameters will apply, which applies for service of summons.
जी जी
Whether it is through WhatsApp or it is by fixing it on the outer door of the accused or
जी।
to some relatives, near dears.
जो भी लॉफुल वेज है सर्विस के वो तो प्रोसीजर हैज टू बी फॉलोड। जी
सर I have a small query. ये जो 7 years से नीचे का अभी जो नया BNSS में है, तो is arrest mandatory
नो
for production of charge sheet?
नो
Because the charge sheet includes the arrest memo form along with that 10-digit print. So if the arrest is not mandatory, why they are making that arrest, filling up that whole form and making it part of the charge sheet?
वो बायोमेट्रिक लेना वो अलग बात है, उसका अलग पर्पस है। लेकिन
But वो
arrest
arrest
करना जो
memo form ऊपर उसके लिखा होता है arrest memo form.
जी
So virtually they are making an arrest.
अच्छा
If the form is filled,
जी जी
that means it's documented. The
जी
arrest is documented.
जी जी
But once under the new scheme,
जी जी
the arrest is not mandatory. So
इवन
why that form should be filled up in the first instance?
अगर करते भी हैं उसी दिन करते हैं वो फॉर्मेलिटीज कंप्लीट, दैट्स डन जस्ट फॉर द सेक ऑफ फॉर्मेलिटी के इनको प्रोड्यूस करना है कोर्ट में, तो उसके
But
बाद
he can otherwise be notified to come before the court. If he doesn't come, then arrest is
यस
mandatory.
यस यस यस
But otherwise under the new scheme, there is no word of arrest. And by filling up the form, they are documenting that yes, he was under arrest.
ही वाज अरेस्टेड।
Once 41 below 7 years is issued, so arrest is exempt.
That's what I'm saying.
They cannot make arrest.
So they are making a form which is part of the charge sheet and it says arrest memo.
यस 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 यू आर राइट, दे शुड सिंपली इशू अ नोटिस फॉर अपीयरेंस। यस 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 देयर इज नो क्वेश्चन ऑफ अरेस्टिंग एंड फिलिंग अप ऑल दैट फॉर्म्स।
Sir, एक issue थोड़ा सा discuss करना दो, that is not relevant, but practically we want to know about that because of your experience and other, maybe other, they may have come across through those instances. In one of the district, an FIR is registered for the commission of crime under section 366, 376, 3 POXO, probably 4 POXO. Accused is arrested. He is produced before one of the magistrate. He remands him in police custody for certain days. Thereafter, on the expiry of first remand, the accused is produced before another magistrate, along with for recording the statement of that prosecutrix also. The second magistrate, he records the statement of the prosecutrix, and she negates all those allegations which are necessary for 376 and 4 or 3 POXO Act. Then the magistrate passes an order that since after going through the statement of the prosecutrix, it is unnecessary to detain the accused for the commission of crime under 376 and POXO Act. But simultaneously, he also holds that since the magistrate cannot decide any case arising out of the POXO Act, therefore the accused is forwarded to the principal district and session judge. When the accused is taken to the principal session judge, he observes that the magistrate has not passed an express order as to how he is barred from deciding cases arising out of POXO Act, be that as it may, and he remands the accused for 376 and 4 POXO Act. Thereafter, another remand comes. Remand form is filled with 376, 366, 4 POXO Act. The principal district judge again remands him for that. On expiry of that second remand before the principal district and session judge, when the IO goes back, he collects medical evidence. After collecting the medical evidence, he finds that no spermatozoa, etc., which are necessary for constitution of 376 and POXO Act are there. He drops all those offenses and properly writes in a Zimini case diary. And next time he goes again before that principal session judge for seeking remand under section 366 and some one more offense which are exclusively triable by magistrate. Now 366 or 367, I think that is triable by court of sessions. But remand can be granted by the magistrate. But principal district judge again remands him for that offenses minus 376 and for POXO Act. Now the question is, once the IO drops 376 and 4 POXO Act, after those remands which have been given by the principal session judge, whether those remands are legally good or bad.
See, that is something which has happened. You are narrating from some incident. आपने कोई जो इंसिडेंट ऐसा हुआ है जहाँ पे आपने जी ऑब्जर्व किया है, वहां से आप नरेट कर रहे हैं कहीं हुआ है, यही है ना कि कहीं हुआ है जी. अब इट्स नॉट प्रॉपर टू पास जजमेंट किसने क्या किया है, बट यस 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 आप देखें तो इफेक्टिवली ही हैज नॉट used the CD files which he is supposed to go through before granting remand, even judicial remand. You have to see whether investigation, that's the only area where you are controlling the investigation, where you can issue directions, supervise the investigation. So जब तक आप CD फाइल नहीं देखेंगे तो otherwise this will go on. इन्वेस्टिगेशन में भी कंप्लीट अब 24 घंटे में नहीं होती है, तो 4 दिन में भी हो सकती है, 10 दिन में भी हो सकती है. जरूरी थोड़ा है कि अगर 90 डेज अलाउड है तो 90 दिन या 60 डेज तक ही उसको खींचना है.
My question is whether that remand period,
जी,
whether that is a curable defect or that is a legal remand or that is an illegal remand. If it is an illegal, whether that detention will be illegal or not.
so
That is the question.
that is to be seen by the
I might
higher
have
court.
tried
If it
to
is,
find out any
if
law.
it is questioned, then it is to be seen by the higher court. Yes, it is to be seen by that. Leave it aside. Let's not comment.
ड्रॉप नहीं करेगा ये सेक्शंस तो तब तक तो डिफिकल्ट है. The command order is always not a mechanical, never a mechanical.
Yes.
Of the judicial mind of the judge, the CD5.
Yes, yes.
The judge at the time of giving the remand must read the CD5 and then come to a conclusion that the offences per se are made out of these, warranting the remand of the evidence. To that extent, the legality of the order would stand, because if it comes from the judicial mind of the remanding authority, magistrate, judge, whether the application of mind was correct or not is the subject matter of adjudication by the Honorable High Court. But insofar as there has been an application of mind and then a remand, so yes, the remand order at that relevant point of time would stand. How far it was correct or not would be seen. The application is to be seen by law.
No, question is whether session judge can give a remand for an offense for which magistrate is not. That is the sole question.
That is post child.
That is the only way. Leave that.
At the time when POXO was still breathing like
Leave that.
Session judge is competent to govern. Being a secondary authority also.
Yeah.
It is not exclusively tribal by magistrate and secondary has lost control. Because I remember, that something like this, we had a colleague. So he was at one particular place, CJ. And, PDJ and CJ were sharing the car. So many a times the PDJ would rise late, like 6:30, 7 o'clock. So the CGM, because alternative days they were sharing the car. One day it was CGM who was using the car. Another day it was the PDJ who was using the car. So the day CGM had to wait extra 2 hours to wait for the PDJ. So one fine day we were sitting and he said, "Yaar, tang aa gaya main se." I quoted him. Now I don't remember the section, but that time I did remember it. Something 400 in old CRPC. I said, if you are ever in doubt, please go through that section. It reads that all the magistrates, including the chief judicial magistrate, are subordinate to the districts and sessions judge. So whenever you are in doubt and you are waiting, you must go through that section, which will remind you that you are subordinate to him and you have to continue.
Supposed to wait.
Thank you.
It's not really the magistrate and then the magistrate. Can session judge can give remand.
Always.
Magistrate.
Always. Always. He is always superior. Don't search it. I can give you that section. Wait, I'll have to search it. Something like that.
Patients, they perhaps or 15 के बाद
So that was basically told to him that you
The situation I have faced when I was posted as some in some district, I have given remand up to 15 days. After that, remand was asked for PDJ. By that time, a statement of prosecutor was done, and she negated all the allegation. Then PDJ, whoever was that, he write in the remand order that I have produced the CD file, and from the statement of prosecutor and evidence collected, I am satisfied that PASCO and 376 not made out. But and the other offenses which are sought, remand is sought in, that has to be dealt by the magistrate. Then he write in the order, then produce this accused before competent magistrate for seeking remand for those sections. In that case also, IU has not dropped the offense, but in the Zimini he has mentioned, and PDJ sir, he go through the statement and
Yes, yes.
specific order.
That reflects the application of mine.
After that, magistrate, whether gave remand or not, I don't know, but
Yes,
that
yes.
order was there by the PDJ.
Yes, yes. That's sufficient compliance to the provisions.
It is written in the provision that it is the only magistrate can give the remand. Not written magistrate or session judge.
Yes,
Only word magistrate is. So where there is word magistrate, we have the magistrate only competent to do remand in court.
Sir, may
That where the magistrate can have some special.
He has regional power.
he has proposed provision under POCSO Act.
He has regional power. It's also against the उसके पास है.
I'll just see. Suppose a particular section under POCSO Act is there, but also under IPC is there, perhaps one or two, and these are just enough. Please allow me to complete. So, and suppose the remand application comes to the sessions judge, and now he proceeds to give remand. Does he say, I will give remand only in POCSO
No.
and not in other sections?
No.
Meaning
You are misunderstanding. Now I am asking you, ask that about POCSO. I am simply asking that a second judge can give them those offenses on which only magistrate is found.
I'm coming to that.
Forget
Coming to that one, sir. So insofar as POCSO, so he is competent and so he gave the remand. What about the IPC sections under which he also gave remand by virtue of the same order?
Not like
The
that.
IPC section
Not-
also.
It's not like that. We cannot even, then we need to say that we should also segregate the trial.
Certainly not.
The law
That's
is,
what I said.
yeah, and it's, but One of the offenses by subsections. Other offenses are to be tried.
Perhaps you're not getting. It's just that there is a composite remand application, even under the sessions seems to be demanding offenses which are otherwise triable by a magistrate, irrespective of the fact that now they are, as per the schedule 1 of the CRPC, they are said to be triable by the superior authority, and hence its power for offenses designated for magistrates.
Please.
I request you that in case of offences punishable with 7 years, no arrest shall be made.
Please,
In case of offences punishable with 7 years imprisonment,
7 years or more.
no arrest shall be made ordinarily. What about the special offences or under NDPS Act, under UAPA, under POCSO?
So
If those offences are punishable with 7 years,
special legislations are saved. Those are saved.
crime against women, etc.
Yes.
It is self-contained.
तो उसको TRPC
The punishment is up to 7 years, whether it could be applicable uniformly all cases or whether.
only under IP.
Special act, sir, I'm not discussing the special act, I'm saying that it is crime against women, crime against victims, sections are nothing here. Whether it would be uniformly applicable to all the cases with the punishment up to 7 years, the police cannot made arrest. That's the. So it is not on the opportunity at the partial, what it is, that's under IPC, all the offences with punishment up to 7 years. The provision is that arrest should not be made. But so exceptions, with regard to legal sections and all that, crime against women.
See, there are certain special legislations like Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. वहां पे जो एंटिसिपेटरी बेल का प्रोविजन है ना, वो स्पेसिफिकली एक्सक्लूडेड है. ठीक है. सो एंटिसिपेटरी बेल कांट बी ग्रांटेड इन दोज केसेस. बाकी जो फॉर बेल पर्पसेस, सो सेम यार्डस्टिक्स हैव टू बी अप्लाइड. ये तो इसी में सिद्धार्थ की जजमेंट में जो है ना, इसी में क्लियर किया गया है.
माइक यूज करें, बाहर की आवाज बड़ी कम जाए.
By magistrates, transfer of cases by
जी yes sir. What was your question, please? Can you repeat the question? Special offences punishable with imprisonment less than 7 years. Less than 7 years. What do you think? What is your opinion? No. If law is silent, then what should be the? Ordinarily, these are the beneficial legislations intended to give effect to the constitutional rights of the individuals. So these should be available to each and everyone, unless prohibited. There is a prohibition. तो मुझे नहीं लगता कि इसमें कोई बाहर है. उनको यही बेनिफिट उनको भी होना चाहिए. जो बेनिफिशियल लेजिस्लेशन है ना, उसका सबको होता है जब तक कोई प्रोहिबिशन ना हो. 7 साल तक जिन केसेस में सजा है और उसमें कोई ऐसी कोई प्रोहिबिशन नहीं है, तो उसमें सेम प्रोसीजर शुड बी फॉलोड इन दोज केसेस आल्सो, इजंट इट? Habitual offenders is a separate class. Habitual भी आप एक होता है कि ये एक अक्यूज्ड है, कन्विक्शन उसकी कहीं नहीं हुई है, लेकिन उसकी इन्वॉल्वमेंट मल्टीपल केसेस में. मल्टीपल केसेस में। सो अब जैसे जे बेल प्रोविजन में इसमें सीआरपीसी में भी प्रोविजन था और वही प्रोविजन इसमें भी रेप्लिकेट किया हुआ है बीएनएसएस में भी कि फर्स्ट टाइम ऑफेंडर है, ठीक है, एक ऑफेंस में इन्वॉल्व है, तो ऑन कंप्लीशन ऑफ 1/3 ऑफ मैक्सिमम सेंटेंस ही शैल बी रिलीज ऑन बेल, ठीक है। उसको बेनिफिट वहां कंसेशन है। इसमें जो बेल लॉ एंड बेल्स जो भी है इसमें कोई ज्यादा चेंजेस नहीं है, बस 2-3 कॉस्मेटिक चेंजेस है। एक तो जो फर्स्ट टाइम ऑफेंडर है, एक केस में इन्वॉल्व, एक ऑफेंस में इन्वॉल्व है, उसको पहले तो जो 436A थी उसमें हाफ था, इसमें उसको फर्दर कंसेशन दी गई है 1/3 किया हुआ। लेकिन जो मल्टीपल ऑफेंसेस में जब मल्टीपल केसेस इन्वॉल्व है उसको जो बेनिफिट स्पेशली एक्सक्लूड किया है उसको, जो मल्टीपल केसेस में इन्वॉल्व है, जब मल्टीपल ऑफेंसेस में चाहे सिंगल केस में भी he is not entitled to be released on bail upon completion of the half of term.
There seems also a confusion with regard to multiple cases.
Yeah.
States that he has been charged for different and not cases. So earlier when advocate Mr. Sakal Bhushan, he was there, he said that
Yeah.
even amendment has been sought from honorable bar members of honorable Supreme Court. That it should be distinct that a person has been charged. Because charge has not been specifically defined that for one offence or other offences, or it is with regard to pending cases. Even this query has been submitted to Law Department for clarifying with regard to pending cases.
सेक्शन 479 ये जो रेलिवेंट प्रोविजन है ना, where a person has during the period of investigation, inquiry or a trial under the Sanhita of an offence under any law, not being an offence for which the punishment of death or life imprisonment has been specified as one of the punishments under that law, undergone detention for a period extending up to 1/2 of the maximum period of the imprisonment specified for that offence under that law, he shall be released by the court on bail, provided that where such person is a first time offender who has never been, ये further clarify किया हुआ है, who has never been convicted of any offence in the past, he shall be released on bond by the court if he has undergone detention for a period extending up to 1/3 of the maximum period of imprisonment specified for that offence under that law, provided further that the court may, after hearing the public prosecutor and for the reasons to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the sentence. The next जो provision है वो relevant है, provided also that no such person shall in any case be detained during the period of investigation, inquiry or trial for more than maximum of the period of imprisonment, notwithstanding anything contained in subsection 1 and subject to the third proviso thereof, where an investigation, inquiry, or trial is more than one trial in more than one offense or in multiple cases are pending against a person, he shall not be released on bail by that court. Yes, yes.
It has not been clarified anywhere.
Which, what is to be clarified? Notwithstanding anything in subsection 1. And subject to the third proviso thereof, where an investigation, inquiry, or trial in more than one offense or in multiple cases are pending against an individual. First part is inquiry or trial in respect of more than one offense or in multiple cases are pending against a person, he shall not be released on bail by the court. So this benefit is not extended to the person who is involved in more than one offenses in same case and multiple cases which are pending inquiry trial, inquiry or trial.
Baseline that being benefited under this provision would ought to have been convicted or simply pendency of charges against.
Pendency of charge sheets. That will spy. Conviction is not the requirement.
So wouldn't it affect this definition of habitual offenders and all that?
Habitual offenders is something which is
Because it has to be applicable in this same.
simply a person, if he is facing trial in more than one cases, he is not entitled to benefit of this case, this provision, this section. Conviction is not the only.
Pendency of cases.
Pendency of cases is sufficient. Otherwise, also in one case, if he is involved in more than one offenses, in one case only, he is not to be given the benefit of this provision. So it is mere pendency of the cases. Conviction is not the criteria. Yeah. जी.
Under the CRPC, at the time of the cognizance, for taking cognizance, we have to record the statement of the complainant as well as the witnesses. After that, court has taken the cognizance.
Right.
Sir, in BNSS Act code, someone says ki statement should be recorded. Someone says statement should not be recorded. Simply issue notice to the accused, and after that, hearing both the parties. Sir, according to language written in the new section, if presiding officer recorded statement of the complainant as well as the witnesses, that means he has applied his mind and cognizance has been taken. Someone says ki go and record the statements of the witnesses as well as the complainant, and after that issue the notice to the accused. Sir, when statement has been recorded in the court, that means the presiding officer has applied his mind and cognizance has been taken. Sir, there is a slight little bit confusion, please, sir. Section 2.
223.
So,
223 you are referring. 223 है? हाँ. जी. जी. 223 yes.
हाँ.
तो सरसरी बयान लो एकदम इसमें चीज दोनों में फर्क है।
ये सरसी बयान फरवरी वाले कॉन्फ्रेंस में
थोड़ा सा ठीक बोलता था आप तो नहीं है चार सही समय नोटिस देना ना पहले उसको इसका बयान किया
Just, just please.
सर में कहा बकरी बिकम मुर्गी
Section 223 as a, which corresponds to section 202. Examination of complainant. A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath the complainant and the witnesses present, if any, and the substance of such examination shall be reduced into writing and shall be signed by the complainant and the witnesses and also by the magistrate. ये तो जैसे 202 है वही सेम ही है उसको रिप्रोडक्शन है. Provided that no cognizance of an offence shall be taken by the magistrate without giving the accused an opportunity of being heard. Yes. Yes.
Provision says, sir, provision says, I think have been on the statement when cognizance is taken. But prior to taking of cognizance, notice has to be issued. There are two
That means statement.
one is taking of cognizance and other is issuance of notice. So far as I can understand, our issuance of notice statement of the cognizance. But taking cognizance.
Cognizance of offense. Okay.
By cognizance. By cognizance. Now we cannot record because we have to issue notice to it. Because the provider is located with the.
along with the
So tired also.
So, just a minute, please. So according to you, just according to you, the complainant, once complaint is filed, complainant and witnesses are present, but you would not record the statements without putting the accused to notice. You mean that? You are reading it like that. Is it? Okay. Yes. Yeah. Yes.
That's why.
Yes.
Yes.
Just please. These are the questions which you would be facing.
Okay, notice issue करने से पहले भी you know have to call some kind of restriction. Why issue notice? Should it be in
Just a minute, please. जी, Mr. Bath. Please. आपका क्या व्यू है प्लीज बताइए. अच्छा, ठीक. Okay, I got your point, please. So according to your statement has to be recorded. Thereafter notice is to be issued. Yes.
Hello.
Anyone else, please? Yes. Please. Just take the mic, please.
saying the cognizance is taken once the statement of the complainant and his or her witnesses is recorded. The proviso says that no cognizance shall be taken by the magistrate before issuing a notice, before granting the accused an opportunity of being heard. So once you're recording the statement of the complainant and the witness, you have taken the cognizance. So, so it's a like a pre-cognizant stage. That will tantamount to taking of the cognizance.
Okay.
That would tantamount to taking of the cognizance.
The final word comes from some superior court because hearing of accused defined specifically whether whether he would be given right to rebut the things that had been given. So at this, the literal meaning is simply that when a complaint is filed, notice has to be issued, and the other side will come, he would be heard. How he would be heard, whether he would be given rebuttal, this right of rebuttal, or whether he would be allowed for cross-examine, all that, it is all silent now.
Okay.
Question arises that to what extent accused has to be heard in the matter while taking cognizance of the
Okay.
private complaint.
Okay, I got your point.
That is the issue which is arising. Whether he can file written objections to the matter, or whether he has to be given an opportunity where he can rebut the private complaint that has been filed. That is the issue which arises in the matter and which has to be dealt
Okay.
by the superior court.
The only confusion related to this proviso that the accused has to be put on notice before taking cognizance. Now the accused is before the magistrate. Now the only question is that whether we have to insist upon the accused to file his objections or his statement, like written statement, as to what his stand vis-a-vis the allegations contained in the complaint. Now this is the confusion which has to be addressed.
Okay. Go.
Once you issue notice to the accused, that means the accused has right to cross-examine the preliminary statement also. Because accused is present, and if he wants to cross-examine the statement of the complainant at the very first instance.
Sir,
Just a minute, please. Please.
sir, the question is with respect to the word cognizance. Sir, supposingly if we record the statement of the complainant.
ये माइक चल नहीं रहे हैं, माइक क्या बात है? Just a minute, please.
Sir, the question is only with respect to the word cognizance. Sir, supposingly, like first. Fusion is with respect to the word cognizance, sir. Sir, there may be instances where we'll record the statement of the complainant as well as the witness, and we'll found that no offense is made out. We'll straight away dismiss the complaint. But here in this case, when we have to issue the notice, but whether we have to issue the notice to the accused once the complaint is filed, or we have to record the statement of the complainant and witnesses, and then we have to issue notice to the accused.
Right. Any of the trainees, please, पीछे.
Proviso clearly says that no cognizance.
Akash ji, please, just a minute. Akash ji, please. आपका क्या कहना है?
Sir,
What is your take?
reading section 223, it specifically states that it has to be at a pre-cognizance stage. Meaning that under the proviso, and the proviso specifically says that an opportunity to be heard has to be given. Specifically meaning that a mere notice will not work. He has to be given an opportunity to rebut the complaint. What has been stated by the complainant, he has to be given a proper opportunity of of filing his objections against that complaint. Further, section 223, under that, what it simply means is what we can do, I think what judicial magistrates can do at this point is whenever a complaint comes, we can just make a record to that effect that a complaint has been presented to us, issue a notice to the
Yes,
accused, issue a notice to the accused without recording the statement of the complainant. And then, sir, after hearing him, if we find that there is a prima facie case, we can record the statement of the complainant and we can take the cognizance under that way.
Okay, right. Anyone else, please? So there are two views. Some of you are saying that on mere filing of the complaint, notice has to go to the accused. And the officers on the other side are of the view that after recording the statements of the complainant and the witnesses who are present, only that notice is to be served upon the accused. You see, what is the proviso reads? A magistrate having jurisdiction while taking cognizance of an offence on complaint shall examine upon oath complainant and the witnesses present, if any, and the substance of the such examination shall be reduced into writing and shall be signed by the complainant and the witnesses and also by the magistrate, provided it's a proviso to the section, main part, provided that no cognizance of an offense shall be taken. See, there is a difference between taking the cognizance of the offense and filing of the complaint. Just because complaint is filed doesn't mean that cognizance of the offense is taken, right? With the complaint, complainant comes with certain allegations that I have been wronged this way, that way, this happened, that happened. So by entertaining the complaint, you don't take cognizance of the offense. It is only for that purpose, for taking cognizance of the offense, you ask him to depose, you ask him to produce witnesses, and after he produces witnesses, thereafter you take the cognizance of the offense and then issue notice to the person whosoever is complained against. So cognizance of the offense happens afterwards. So here, as the sequence of the section itself reflects, first you have to file the, whenever complaint is filed, first you have to record the statement of the complainant and the witnesses whosoever are present. And if some offense is made out, as one of the officers pointed out, if no offense is made out, dismiss it. If some offense is made out, लगता है कि कुछ offense बनता है इसमें, then only accused is to be put to notice. Isn't it? जी. Dismiss the complaint, that's all. Yeah? Section doesn't में corresponding section तो इसमें भी है. उसके लिए तो बस डिसमिसल के लिए तो कोई आपको स्पेसिफिक सेक्शन की अदरवाइज भी जरूरत नहीं है. Yes.
When a person applies his mind whether the complaint will proceed or it would be dropped. Once he applies his mind, that is cognizance.
Cognizance of what?
Cognizance of matter that has been placed before him.
Matter का नहीं है ना, offense का है. Cognizance is to be taken of the offense.
Appreciate करेंगे complaint को तो offense का पता चलेगा सर.
इसीलिए तो उसको सुनना है ना.
अब 138 हमारे पास है, चेक वाला सारा कुछ है उसमें. जैसे 138 की कंप्लेंट्स आ रही है. जी. हमें वैसा ही है कि हमें उसको क्या करना, but actually how we have to proceed.
138 में कंप्लेनेंट की स्टेटमेंट रिकॉर्ड की जाती है, क्या उसमें एफिडेविट भी फाइल किया जाता है मेरे ख्याल में? तो उसमें विटनेसेस को एग्जामिन किया जाता है 138 में? फिर हैं? एक मिनट आप उसके लिए इसी में प्रोविजन है ना, जो नेक्स्ट प्रोविजन है ना, प्रोवाइडेड फर्दर that when the complaint is made in writing, the magistrate need not examine the complainant and the witnesses. If a public servant acting or purporting to act in the discharge of his official duties or a court has made the complaint.
But in public service, but what about 130? Public file.
130, 138 में तो उसमें तो
Once of 138 is made out, then it will further delay the proceedings when we will issue notice to the accused.
आप क्या कहते हो 138 में? Yes, yes, yes. Yes, yes. जी. हाँ. जी जी. इनका क्वेश्चन है कि क्या 138 की कंप्लेंट में जो डॉक्यूमेंट पे बेस्ड है कंप्लेंट, तो उसमें नोटिस इशू करना है कि उसको नहीं करना है बिफोर टेकिंग कॉग्निजेंस ऑफ द ऑफेंस?
Directive आ गया सर में.
जी.
Distinguish any.
Yes, 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 irrespective of. Yes. So notice has to go to.
Appear the magistrate there is commission of 130. Summon to the accused.
जी.
The 223 is talking about the first section of it. Sir is talking,
आप थोड़ा सा.
section 223, sir, is talking, the first subsection of 223 is talking about the procedure while taking cognizance. It proceeds to tell the magistrate what all the magistrate is required to do during the process of taking cognizance. But the proviso is a kind of a caution to the magistrate to tell him, that before taking any cognizance of an offense, issuance of notice is mandatory to the accused. So, one से भी पहले जब हम sir, we have entered into that process, we stepped on that first stage of taking cognizance. उससे पहले सर notice issue करना accused को proviso के हिसाब से I believe mandatory. Take to calculation.
जी. See. क्रिमिनल कंप्लेंट्स में बिफोर 2004 अदालत प्रसाद जजमेंट आफ्टर कॉग्निजेंस अक्यूज्ड जनरली आते थे, एप्लीकेशन फॉर ड्रॉपिंग ऑफ प्रोसीडिंग्स फाइल करते थे, एंड आफ्टर हियरिंग बोथ साइड्स कोर्ट डिसाइड करती थी कि ये कंप्लेंट आगे चलना है कि नहीं चलना है. सो इन ए वे power was with the trial court, the first court, to see whether this complaint is worth proceeding or not. Now, after Adalat Prasad's judgment, that power was taken away. The Supreme Court held that once magistrate has passed some order, he can't review that order because power of review is not there. So if someone is aggrieved, he has to approach the high courts in a revisional jurisdiction. So इससे क्या हुआ कि बहुत से cases which were not fit for trial, which merited dismissal at the very outset, they ultimately either landed before the superior courts, thereby increasing the pendency, or the people who couldn't afford had to face the proceedings for years together. So I think for just to correct that and to check that this right has been given, this proviso has been added, and the right to hearing is given to the accused at the pre-cognizance stage, so as to see only that only those cases where actually a case is made out are filed, and whatever chaff is there, that is discarded at the very outset. That is the holistic purpose. Now, how it is to be applied and how it is to be seen, it is up to you, and it has to be seen on case to case basis. वो complaint क्या आती है, उसमें क्या material है, offense बनता है कि नहीं बनता है, और after that too after hearing the accused, वो आपको देखना है. जी, जी, जी. Anything else? जी. Trainees, please. आप चुपचाप बैठे हो पीछे, क्या बात है? Snover Gulzar, please. हाँ. Anything? Nothing? Okay. Yeah. Don't feel shy. You must learn from the senior magistrates present over here. Yes, yes.
In this BNSS, there's a new provision. We also raised a question in Bhopal CAPT, trial in absentia. I think this is 356. And a similar provision at par with the corresponding provision of JKCRPC 512, 299. A record of evidence in absence of accused. My question is that in what scenarios these two provisions shall come into operation?
Okay. जो 512 जिसकी आप बात कर रहे हो, इसमें CRPC में जो सेंट्रल है 299 है. ओके. सो हाँ, तो जो पहली सेक्शन थी उसका अलग पर्पस था. दैट वाज ओनली टू प्रिजर्व एविडेंस. बट मोस्टली क्या होता था कि 512 की रिक्वेस्ट आई, एक तमीली आता था एट द वेरी फर्स्ट डे, चालान जिस दिन प्रेजेंट किया है उसी दिन उसकी स्टेटमेंट रिकॉर्ड हो गई, और उसी दिन 512 कंसाइन टू रिकॉर्ड हो गया, विच वाज रॉन्ग प्रोसीजर. जब अक्यूज्ड एब्सकॉन्ड कर रहा है तो उसको एब्सकॉन्डर डिक्लेयर करने से पहले you have to follow the procedure which is prescribed from section 2 from 82 onwards, 86, 87. Yes. So proclamation issue, पहले तो वारंट इशू करना है, उसके बाद proclamation इशू करनी है, calling upon him to surrender within 30 days. उसके बाद अगर नहीं आता है तो उसके बाद You can go for attachment of property. जहाँ उसकी property है, अब property नहीं है, then you have property attachment is one part. But thereafter you can declare him as absconder. उसके बाद जो material witnesses हैं, अब पुराने टाइम में जो हमने देखा है, जो हमारे से सीनियर जुडिशियल ऑफिसर्स थे, दे यूज टू रिकॉर्ड दी मटेरियल विटनेसेस, सो दैट विटनेस किसी की डेथ हो जाती है, जब टाइम के साथ साथ मेमोरी फेड हो जाती है, अनपढ़ लोग खासकर जो विटनेसेस हैं, तो जस्ट टू प्रिजर्व द एविडेंस उनकी स्टेटमेंट्स रिकॉर्ड करते थे जो मटेरियल विटनेसेस है। उसके बाद अक्यूज अगर तब तक अगर ट्रेस नहीं हुआ था तो then it was consigned to records for some time till the accused was arrested. तो जब उसको अरेस्ट किया जाता था फिर उसको then he had to face the trial. बट वो जो एविडेंस प्रिजर्व, अगर उनमें से कोई विटनेसेस की डेथ हो गई है, ठीक है, जहाँ अनेबल टू डिपोज है, अदरवाइज जहाँ whose presence can't be procured without wasting certain amount of time. So in that situation, the trial court had the option to use that evidence against the accused. In that way, he can't say later on that I have not been given the opportunity to cross-examine the witness. So he, in a way, lost that right because of his own conduct. So that was the purpose of declaring absconder and all that. Now, trial in absentia, this is a new concept. So accused, if he doesn't turn up, I think within 3 months is the time, and thereafter, he can be tried in his absence. He can be even punished, sentenced. So if ultimately he is convicted, sentence is to be pronounced, it will be executed once he is arrested. So now he can be convicted in absence. That is the change which has been brought in this law. Which provision?
जो 500, the earlier was 512
जी,
and
जी।
299 CRPC 73.
जी।
The similar provision is still there in BNSS 335, I guess.
प्रोसीजर तो उसका absconder declare करने के लिए वही है ना?
But in this trial in absentia, proclamation has to be issued also.
Yes, yes. These are the corrective steps which are to be taken in any case. These are the part of the procedure for declaring anybody as absconder. ठीक है ना?
The difficulty arises, suppose a charge sheet is presented before a magistrate.
Right.
And that requires committal. And 3 accused persons are in judicial custody and 2 are absconding.
Yes.
And now if we follow the procedure of 82, 83 and then abscond, then that will put a question mark on the fair and speedy trial to those 3 accused persons who are in custody. And in that scenario, what do we have to do? We have to secure the presence of accused. तो सर हम उसमें यही करते हैं कि statement record करके we proceed under 512 against those accused persons.
No, अगर कुछ केसेस में जहाँ पे ज्यादा टाइम लगता है ना, वैसे this process can be completed within reasonable time. ठीक है ना? Yes. तो even charge frame करने के लिए भी 60 days का पीरियड है. तो ये उससे पहले कंप्लीट हो सकती है. 15 दिन का नोटिस उसको वारंट करो, अगर नहीं होता तो उसके बाद 30 डेज का नोटिस कर दो, उसके बाद यू कैन. बट जहाँ पे ज्यादा डिले हो जाता है वहां पे ट्रायल कैन बी सेग्रीगेटेड. Yes, yes. Yes, yes. Yes. Yes.
After bifurcation, the separate challan shall be committed.
उसको उसी चार्जशीट में ट्रायल सेग्रीगेट किया जा सकता है, सेपरेट चार्जशीट की जरूरत नहीं है, उसी चार्जशीट में यू मे प्रोसीड टू ट्राई दी पर्सन्स हु आर प्रेजेंट। वो उसका जो है वो उसका बहुत बाद में व्हेनेवर ही इज उसका तो
510 में
जी
सर मैजिस्ट्रेट तो उसको बाइफरकेट नहीं करेगा ना।
नहीं, बाइफरकेट करना तो मैजिस्ट्रेट का पार्ट नहीं है ना, तो ना ही आप उसको कह सकते हैं कि उसके लिए अलग चार्जशीट करो, या एक को अलग करो, दूसरे को आप उसमें ऑर्डर में लिख दो कि ही विल बी ट्राइड सेपरेटली। जी
Subsection 2 of the JNT I'm not sure about this. Wherein the trials can be segregated.
Yes, yes.
The presence of certain accused cannot be.
procured, yes, yes, yes. Trial is to be split. Yes. आपको ऑनेस्टली जो लगता है ना गुड फेथ में वो करो, अगर गलत भी हो जाएगा तो हायर कोर्ट से करेक्ट करने के लिए, बट ये so thank you all once again. So please enjoy lunch before leaving. Thank you.
Okay.